Welcome everyone to the 9th District Court of Appeals. We're going to hear several cases today. The first case is State of Ohio versus Kevin McClellan. Before we begin, though, I'd like to welcome my two new colleagues to the bench with me. This is Judge Jill Lanziger and Judge Scott Stevenson. So I welcome them, and it's a pleasure to serve with you. Each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes for rebuttal. You all see the screen over there. We will be keeping track up here of your time, and that'll give you an idea of how much time you have left as well. Please don't mention the names of any victims or the names of children in your presentations to the court. We are recording this. It will be on YouTube and be accessible to the public. If council is ready to begin, we are ready to start.
Thank you, Your Honor. May it please the court. We'd like to reserve 5 minutes for rebuttal.
Thank you.
My name is Attorney Wesley Buchanan. I have the privilege of representing Kevin McClellan in the matter. He is the appellant. At the outset, Kevin would note that he did enter into a criminal Rule 11 plea colloquy with the court. We had retained counsel. He did plead guilty. There was a written plea of guilty as well. He also understands that he did file his motion to withdraw after he was sentenced. And then the court denied that without a hearing, and then this instant appeal followed. So Kevin would like the court to remand, at a minimum, to hold a hearing on his motion to withdraw his plea, or just permit Kevin to withdraw his plea. Kevin understands that he has to show the heavy burden of manifest injustice. And here is why manifest injustice would apply to Kevin's case. First, the facts of the matter are that in May 1999, there was an allegation of rape by CL in the University of Akron. Police investigate, and she submits to a sexual assault kit in 1999. The police investigate, they take photographs, they take Kevin's personal information, and they interview witnesses. Later, almost a year later, in April 2000, the detectives from Akron Police Department closed the case, and they noted that they talked to a police legal advisor, or PLA, and they indicated that they were not recommending to file charges upon the facts of this case, and that was in April of 2000. Or September 2000, the police closed the case. I apologize. So, as we all know, the rules of professional conduct are always effervescent in our lives, and 3.8 for professional conduct, we always has the special notes for the prosecutor. So as of September 2000, no probable cause existed, and they declined to prosecute. However, that doesn't end our story. 13 years later, in January 2013, the police submitted the sexual assault kit for testing. The results were returned to the police in April of 2014. So almost 15 years after the incident had occurred. So another 5 years passed before police contact Kevin. In April 2019, Kevin was contacted by police. Kevin invokes his right to counsel, and that's where the investigation and the conversation with Kevin stops. Then, on May 10th, indicated by the docket, 2019, just 5 days prior to the statute of limitations running for the allegations, the government indicts Kevin for rape. So, his case then proceeds. So the problem that the manifest injustice that Kevin is going to submit to this court is that no probable cause existed in 2000. And then 5 days prior to the statute of limitations, probable cause all of a sudden exists. So by definition, you've got a 19-year, 11-month, 360-day delay. And that's evident by the calendar. So Kevin would indicate that as far when he filed his motion to withdraw, and then he pleads guilty with a written plea of guilt, and that is completely part of the record, the court did not give him a hearing. However, when Kevin filed his motion to withdraw, he did include some medical records, and he did indicate that trial counsel's performance may have been deficient, given the fact of the delay. Pre-indictment delay is a very substantial thing, and it is a real thing. And on the facts of this case, it would be evident to see where if you have a police report, you have an indictment, the charging document, and the indictment says the allegations occurred in 1999, and then we have the calendar, and it's 2019. The first thought in your mind would be, why the delay? What was going on? Especially...
Excuse me, counsel, but that's the whole point here, isn't it? Why the delay?
Correct.
With the sexual kit?
Correct. That is exactly the entire point. And so the way it fits into manifest injustice is because Kevin didn't create the delay. It would be a completely different set of facts if Kevin were to be party to the delay or have caused the delay. Here, the kid sat in an evidence room and was tested in 2014. And that's all in the record. It was tested in 2014, and the indictment did not occur until 2019. So not only do you have an event that occurs in 1999, you don't have testing until 2013, but then you don't, or 2014, then you don't get an indictment, a charging document, which is probable cause, until 2019, 5 days prior to the statute of limitations. So the manifest injustice is there. The rules are in place to restrict and to prevent the government. Now, again, Kevin understands that there was a plea guilty. He did have retained counsel. He entered a written plea guilty. And he understands, again, manifest injustice is a heavy burden to prove. However, given the facts of this case, the file of the motion to withdraw as well, at a minimum, the trial court probably should have held a hearing because Kevin did include medical records indicating that he may have been under the effect of something, whether or not, which goes to whether or not his plea was knowing, intelligently, or voluntarily made. So that's an issue that Kevin has. So the court was going to have a hearing. The trial court, in their decision, references State v. Cargill, 2015, Ohio 661, and that's the journal entry that the trial court issued denying Kevin's motion to withdraw the plea. However, and that's a case from this court. That's a case from the 9th District Court of Appeals here, and it says that an evidentiary hearing on a post-sentence motion to withdraw a guilty plea is not required if, quote, the record indicates that the movement is not entitled to relief and the movement has failed to submit evidentiary documents sufficient to demonstrate a manifest injustice. So Kevin's position would be that the trial court erred twice at a minimum. First, that the trial court did not have a hearing in the matter, even though Kevin did supply necessary documentation to at least indicate that a hearing would be necessary. And in that documentation, there was issues where the discovery may not have all been provided when Kevin entered his guilty plea. Now again, the 8th District Court of Appeals in State v. Jenks and Dickerson 2, State v. Dickerson 2, which are in Kevin's brief, do indicate that that may be sufficient on a prong for a Strickland analysis for effective assistance of counsel. However, while those are not binding upon this court, obviously, they are certainly persuasive and can point to the indicate. Again, Kevin had those medical records. He wanted to have a hearing, and that hearing, at a minimum, would have permitted Kevin and his new counsel to at least examine and say, and in addition, the prosecutor would have been able to present a case and say, no, this is why the plea should be upheld.
Were the medical records submitted by affidavit or under oath, or were they just statements from doctors?
They were a printout, and they were attached. I believe they were attached under seal because of the personal information involved. So on the docket, it does show an Exhibit A to the motion to withdraw. So there was a, I believe, 10-page document, and I believe it was printout. It was not affidavit by a custodian of records or anything else like that, but it was like a printout you might see from like a Cleveland Clinic thing online, and that was submitted.
Do you have any cases that you could cite to the court where ineffective counsel was found to be manifest injustice, required withdrawal or at least a new hearing?
That would be State v. Jenkins and State v. Dickerson in the brief that Kevin filed.
What was the ineffective assistance in those cases?
They were ineffective because they never filed a pre-indictment delay motion on the facts of those cases, which are very analogous to here. Because of such a long timeline, again, the statute of limitations is 20 years, 5 days prior to the statute running, the government indicts him, even though they had the DNA results 5 years previous. So in those two cases, the ineffective was found because trial counsel did not, on those facts, file a motion to dismiss for pre-indictment delay.
Counsel, to follow up Judge Stevenson's question, the state here just didn't meet your initial burden in regard to even necessitating here.
And Kevin understands that. You know, this is an abuse of discretion standard. Kevin understands that as well. So the burden that Kevin would indicate is that he did take the first initial motion to go through the motion to withdraw, went through the analysis that why things would be different and why Kevin was prejudiced. And so that's why Kevin's counsel at the time when they filed a motion to withdraw the plea included those medical informations as well. And I believe I'm almost to my rebuttal time, so if the panel does not have any other questions, I will reserve the rest of my time for rebuttal.
Thank you.
Thank you.
You may proceed.
Thank you, Your Honor. Good morning, and may it please the court, I'm Jack Burnett-Corrigan on behalf of the state, the appellee in this matter. Pre-indictment delay alone does not establish a manifest injustice. And also, purely speculative allegations are never enough to allow a defendant either a hearing on a post-sentencing motion to withdraw a guilty plea or to actually withdraw the guilty plea itself. In response to some of the court's questions, no. Mr. McClellan did not meet his burden in his motion to withdraw his guilty plea. It was deficient on its face because there are a couple things that are required under Criminal Rule 32.1 for a post-sentencing motion to withdraw a guilty plea and to have a hearing on it. And that is, there has to be evidentiary materials that are attached to the motion itself, because the defendant bears the burden to present evidence demonstrating that there is a manifest injustice in order to get that hearing to develop that evidence further. And that's according to not just this court's precedent in the West case, but also in Muhammad from the 10th, Mitchell from the 8th, which were all cited in the state's brief. There is no right to a hearing on one of these motions, and that's the word from this court in State v. Buck. That standard to withdraw a guilty plea post-sentencing is indeed very high, and it's only in the most extraordinary case that it will be allowed. And manifest injustice has to be more than mere error. It has to be some fundamental flaw in the proceedings that caused a manifest miscarriage of justice or resulted in proceedings that don't meet the strictures of due process.
Counsel, I understand what the case law is and everything, and what you said in your briefs, but on its face, this just doesn't look good, does it?
Well, again, the delay itself is not what's dispositive. And one thing that I noticed that was not mentioned is the two-part test from State v. Whiting, and that establishes whether a pre-indictment delay actually causes prejudice to a defendant. And for that, the defendant first bears the burden to demonstrate by actual evidence, not speculation, okay, and not, please let me develop more evidence by conducting a fishing expedition in a hearing, but they have to actually have evidence that he will suffer actual prejudice at a trial because exculpatory evidence was lost due to the delay at hand, okay? And the court could refer back to Perk, which I was on the other side of at the time, where on remand, the court actually in a hearing found that there had been evidence that was exculpatory to Perk that was lost due to a more than, I think it was 25 or it was close to 28 years of delay. However, the second part of that test is that the burden only after the defendant makes that showing. The state then bears the burden to show that the delay was justified, and in Perk that was, because Mr. Perk had actually provided the lie about his wife having killed herself. But the first part of that rests with the defendant, and Mr. McClellan, his counsel could not have made that showing in this case, and so whether he was ineffective or not is not
How
really
do we know
an
he
issue.
couldn't show that if the issue was never raised in trial court in the first place and the motion was heard to discover that? And what evidence there was? I believe the record wouldn't tell me what exculpatory evidence there may or may not have been because it was never read.
Well, it wasn't raised below before the guilty plea, but in his motion to withdraw the guilty plea, he alleges, merely alleges, that a tape of a 911 call, I think his words were, he had a good faith belief that a tape of a 911 call was missing. He had a good faith belief only that photographs of the crime scene may have been missing, okay? There's no indication in the record whatsoever that he ever investigated whether the 911 call tape was extant or whether photographs were.
So you would have us hold the person filing for the motion to withdraw to submit those documents with their motion to prove, here's what I believe the exculpatory evidence was, here's a copy of the 911 call, here's a copy of photographs or whatever else might be.
No, not the evidence itself, and I should make that clear, but an indication as to what efforts have been made to find the evidence that they believe is missing. For instance, with a 911 call, okay? They have a good faith belief in this case that it was missing. A better indication would be, here are the efforts that we made, Mr. McClellan's post-conviction counsel, here are the efforts that we made to go to the police station, do a public records request for that information. Like in Perk, there was evidence in the trial record, and I'm not saying it has to be in the trial record, but there was an indication. The rope that was around her neck had been in the evidence room. It was gone. It had been destroyed per the evidence destruction policies. Same thing with photographs of that crime scene. They had been destroyed. But there's no indication of that here. There's merely a good faith belief without any indication as to what efforts had been made, if any, at all.
Is the case law clear that just raising a good faith belief is not sufficient to establish a need for hearing?
Yes.
What case would that be?
Well, that would be in Whiting, because the Whiting case requires a demonstration by actual evidence that evidence is missing. And I know that sounds like it's a double negative. It's not real. But it's the kind of thing that I'm trying to describe, which is, counsel's efforts to try to find the evidence or, something in the record saying that there is some documentation that says this used to exist, it was in the police records, it was in the evidence room, and now it is gone. And without that evidence, here's why it's relevant to the case, here's why it's potentially exculpatory, and why we can no longer use it. And so I would also, I keep referring to Perk because it's a good, clear example of what was actually missing and how it was actually demonstrated that it was missing. So that's the kind of burden that for Mr. McClellan, had his trial counsel tried to make a motion to dismiss this case on the basis of pre-indictment delay, that's the kind of showing he would have had to have made. And in this case, it's just not done. And getting back to the medical records, okay, it was a treatment note, essentially, that was attached to the motion to withdraw the guilty plea. Plus, I think there was a page that indicated his BiPAP, sleep apnea equipment settings. That's not, it's not notarized, it's not sworn to, it's not an affidavit. All it is a treatment note indicating that Mr. McClellan has a laundry list of conditions, one of which includes memory loss, and there's no indication that that memory loss was severe enough to have actually affected his ability to enter into an involuntary and intelligent guilty plea in this case. So,
Counsel, let me ask you, the appellant seems to be, is differentiating between the original time period until the sexual kit the results were obtained. And then after the results came back, there was another like 4 or 5 years of delay. Do you have the same argument and response in regard to both of those, or are those different?
actually, I do have the same argument, because there still has to be a showing that those delays are actually caused prejudice to Mr. McClellan in the form of missing evidence. And but I would like, I hope that that's answered the court's question, because I would like to raise one point. For the first time here in this oral argument today, we heard an allegation that there was no probable cause to issue these charges back at the time. That was never raised below. It was not even raised in the brief in this case. And it's actually inaccurate, okay? What the record does show is that the police legal advisor at the time indicated that no prosecution would be forthcoming in that police legal advisor's discretion, not because of no probable cause, but because the victim could not be contacted. That's the reason.
And is that actually in the record?
That is what's in the record. Not because that PLA's opinion there was no probable cause. I think there's extrapolation that's being done for the purposes of this argument today, that there must not have been any probable cause because of the application of a professional conduct rule. Again, that was not argued below, and it's not in the record. So, but again, because of the lack of an actual showing that any of the alleged evidence that Mr. McClellan, that his counsel below thought might be missing, there's just such a dearth of evidentiary proof that was attached to his motion to withdraw his guilty plea. The trial court did not abuse its discretion in denying the motion without a hearing. And I just would remind the court about, and I know Judge Carr is extremely well versed in this one, but what an abuse of discretion means. An abuse of discretion means that this court does not get to substitute its judgment for the trial court. What it has to find instead is that this decision was so unjust, so unfair, not from the standpoint of the defendant, but so unjust and so unfair that it indicates a perversity of will on the trial court's part. And some courts actually describe that as an abandonment of a sound legal process. The state submits that in this case there was a sound legal process that underpinned the trial court's decision in this case.
Was the issue of ineffective assistance of counsel raised below as far as the motion to withdraw?
It was. In the context of the ineffectiveness was that counsel had not made the motion to dismiss on the basis of pre-indictment delay. I would remind the court, though, that until the brief in this appeal, there was no allegation below that had trial counsel made that motion, that Mr. McClellan would not nevertheless have entered his guilty plea, which is part of the two-part test for ineffective assistance of counsel in the context of a guilty plea. It's not just objectively deficient performance on the part of trial counsel, but also in the absence of that objectively deficient performance, would the guilty plea still have been entered? So without those two, you don't have an effective assistance in this context. And unless there are any further questions from the court, the state would respectfully rely on the remainder of its brief and ask this court to affirm the judgment below.
Thank you.
Thank you.
Mr. Buchanan, you have 5 minutes for your rebuttal.
Thank you, Your Honor. At the outset, Kevin would note that as far as the allegations being speculative, the calendar is not speculative. This calendar is not speculative. 19 years and 11 months is not a speculative answer. As indicated by the record below for the motion to withdraw, the victim could not be contacted, which implies there's no probable cause to prosecute. The definition of probable cause is satisfied by the indictment. So we'd indicate that as far as the pre-indictment delay is concerned, the record does indicate that the victim could not be contacted in 2000, in September 2000, then what would change in May of 2019? And that leads to the manifest injustice. And again, Kevin understands that this is an abuse of discretion standard. He understands the heavy burden that he has placed on to have his plea withdrawn for these issues. In addition, as far as the evidentiary materials, again, there can't be speculative. The calendar wasn't speculative. The materials that Kevin submitted to the trial court were not speculative. They were medical printouts and everything else like that. So it indicate that he did, at least for the court to at least hold a hearing, satisfy his burden that he had.
But to have the hearing, don't you have to demonstrate some evidence of prejudice?
Correct.
Otherwise, we have a rule just that if there's pre-indictment delay, any attorney to be effective would have to raise the issue at the trial court.
Kevin's position is not that every trial counsel has to file a pre-indictment delay motion. On these facts, where you have an indictment that is 5 days prior to the statute of limitations running, the standard would be, that should be an indication. That should be a clue. If it was, because again, this is the case is cited Perk was a murder case, so there's no statute of limitations, so that's a different story. Here, there is a statute of limitations. So for lack of a better note, if you see an indictment and it was filed and then 5 days later the statute of limitations were to be expiring, then that should draw at least a note what's going on here.
And counsel, obviously, it's two-step word with effective assistance of counsel, so maybe that was not the best thing to do. Maybe he did violate the standards, but you still have to show the prejudice.
Correct. The prejudice being that now you have to force the alleged victim to come to court. And if she can't be found, what does that do to the case? And that's the prejudice. Because if the government then has to subpoena and use compulsory process to bring the alleged victim to court, and if the alleged victim doesn't want to be found, then the prejudice that Kevin would have suffered is how does the government meet their burden? Without the alleged victim, in this case, all the sexual assault kit would demonstrate would be that intercourse occurred, not whether it was consensual. That goes to performance and prejudice. So as far as the kid is concerned, all that demonstrates is something happened, not whether or not it was consensual or not. So to answer the court's question, those are issues that's how the performance would have been. That's how Kevin would have suffered prejudice in this case. And if the panel does not have any other questions, Kevin would ask this court to permit him to withdraw his guilty plea, and if not, permit the minimum remand of the trial court to have a hearing of whether or not he should be able to do so.
Any other questions?
Thank you.
Thank you. Counsel, you know that the court will take the matter under advisement and will issue a written opinion that will be sent to both parties, as well as we release it with the Supreme Court and you can access it electronically too. Thank you so much for your